Okay, over to you. Thank you, Stephen.
So the first thing, I'm going to cover a number of areas and try and give you an insight into how to achieve your goal to be a judge. So I'm going to include an overview of my career path, how to gain some experiences to use in your application and your interview, details about training, coaching and additional qualifications that might help, some bits on competency-based interviews, my own application experiences, including failures, the skills needed to do the job and the difference to practice, and also what you can do now to develop some of these skills for the role of judge. And finally, since I was here, I thought it might be a good idea to give you some inside tips for the day job as well, because I know obviously at the moment that's probably more useful as well sometimes. Yeah, so there's probably nothing unusual in my career path to many of the CILEX members. I started at 17 years old as an apprentice on £35 a week. I was working in a law firm in Durham, and I was studying for what were then the Part 1 CILEX exams. It was well before the days of CILEX, and I was doing that obviously on an evening and a weekend. In my first job, I did a lot of office admin tasks, such as photocopying, covering reception, taking the DX on a night, which meant I got out early for the bus, which was nice. But I also got to shadow a partner that I worked with. And the most interesting part of this was watching him in court, because that was my first ever experience of judges. So at the time, obviously, I was 17-year-old, and I thought these judges must be very special people and really different to me to do such a job, and obviously make important decisions, and never even dreamt at that stage that I'd one day do a similar role. So I eventually moved into personal injury and into a defendant personal injury firm, and I actually started dealing with civil claims against the police and sexual abuse claims. So it was during that time that I qualified as a fellow of CILEX, and well, what was then again still ILEX, should I say, and then started to do more court work as well. So like a lot of you who do litigation, I spent a lot of time in chambers dealing with applications, case management, and what struck me at that stage when I had more involvement was sort of how normal most of the judges seemed, not all of them. I'm sure we all know those judges. But I think this was where really, when I looked back at it, when I was doing this, it was probably where sort of my interest came of one day wanting to be a judge. So back in the day, I went on and qualified as a solicitor as well, because back then CILEX members couldn't be partners or set up their own firms. Obviously that's changed now, which is fantastic. So in 2004, I set up my own law firm, and then I joined CILEX Council in 2005, and I was president in 2013. So during my time on council, I was part of the group of CILEX members that secured the right for fellows to apply for judicial positions. So at that stage, it seemed the obvious thing for me to apply to become a judge as well. So obviously I'll go through my experience, as I said, of applying shortly, but it wasn't until 2016 that I actually secured my first role as a police tribunal judge, and now cover 3 different areas of the country. However, but basically, however you start your journey to become a CILEX fellow, the pathway to be a judge is definitely open to you. So what you've got to do at this stage is really gain the experience to cover the competencies. And obviously the competencies the JSC uses, which if you've looked on the website, which is very useful and I recommend that, are exercising judgment, assimilating and clarifying information, possessing and building knowledge, working and communicating with others, and managing work efficiently. And you need strong examples for all of these, both for your application form and ultimately your interview if you get to that stage. So it's worth going to the JSC website, printing out the page that gives you prompts about all of the competencies, because actually it's quite useful to make you think about what would actually fit into that sort of competency. Obviously, for some applications, your form isn't fully assessed unless you get through to the interview stage. Usually these are the ones where there's pre-interview examinations online. But it is ultimately a vital part of the application, and it will be scored. So it is absolutely vital to get the best you possibly can down on paper. As a first step, like I said, I would work through the JSC page and see what examples you've got now And then I would try and get them down onto paper and keep them down to the usual sort of 300-word limit, because ultimately that's what you'll need to do when you're filling in your application form. They do really need to be detailed as well, and they've got to demonstrate how you meet the competency. For example, in assimilating and clarifying information, it's not really sufficient to say how much evidence there was on the case, what you had to do to decide how to proceed. What the JSC want is a little more involved to demonstrate what techniques you use to do this. For example, did you use a spreadsheet to identify similar fact evidence? How did you classify the evidence you find as to strength or weight? So this all ties into what you would be able to do, well, what you need to be able to do in a judicial role. For example, assess witness credibility. So you need to approach the competencies from the perspective of how a judge would demonstrate them, not from your perspective as a practitioner. So once you've identified the areas where you have examples, you need to keep a printout handy, or obviously digitally, and during work or anything else you're involved in, identify things that might relate to the other competencies. Because some of my examples obviously come from work as a lawyer, obviously, but some of my examples come from my time as a school governor, from my time on CILEX council. So there can be varied places these examples come from. For example, the competency of working and communicating with others. One of the cases I used was about a husband and wife who were Afghan refugees, and they were involved in an accident. There was the obvious language difficulties, of course, but of more relevance were the cultural differences. So I actually had to educate myself about these cultural differences to try and advise the client properly. The husband in this particular case wanted to speak for and give instructions for his wife, because that was the way it worked in his culture. Obviously, I had to educate myself on his culture so I could try and understand his perspective. And by doing that, that enabled me to approach the issue of the importance of getting individual instructions from both of them in a tactful way and with an understanding of why he thought his way was right. So communication isn't purely about language, and if you do it purely based on language, it might not be detailed enough. It goes a little bit deeper, and that's what the JSC want you to go a little bit deeper on that. So if your current job gives you limited opportunities for the competencies, try and look outside the law. I say I've worked as a school governor in the past. That's given me good examples. And obviously local schools are always on the lookout for competent people to help. Local charities, social organisations, local campaign groups often look for volunteers for committees and boards. And you can often obviously help, as well as helping these organisations, you can get some really valuable experience for yourself for applying for judicial roles. So you really need to think about where you can first of all provide some assistance, but where you can get something out of it as well. And just have in mind the competencies when you're doing this and when you're considering any external roles. So there are things out there that I know Louise has mentioned, obviously some of them, but the JSC often as well looks for volunteers for test runs of its assessments. They're normally advertised on the JSC website. And if you really don't want to go into the process without trying it out first, that might be an option for you. There's also various trainers and coaches you can find online that'll do everything from helping you fill in the application form to sort of mock competency-based interviews. And obviously the CILEX scheme, which Louise has mentioned, which is worth applying for. And qualification-wise, beyond obviously the legal qualifications which you need, one thing that's helped me greatly in my role is, and actually to be honest, in work generally, is my mediation qualification. And you don't have to go into doing months and months of study. I did a 10-day certificate, and it's helped me on a number of develop a number of key skills such as active listening, conflict resolution, and it's things I used in the day job and things that are absolutely vital in the job when you're judging a police misconduct hearing. So these type of things are very useful. If you're asked to do role play as well in your application, which in the past I've been asked to do that, which is quite scary. Or obviously when you're describing how you deal with situations in court, such as an angry or inappropriate party, which seems to be one that often comes up, how would you deal with that? So there's numerous providers for mediation courses. It's worth doing a little bit of research and perhaps looking at something that suits you and what you want to get out of it. I mean, I never wanted to be a mediator and run a mediation business. It was purely to develop skills, and that's the way I looked at it. So competency-based interviews, obviously not all interviews are the same. I've had many interviews over the years where, other than a couple of legal questions and what have I done so far in my career, they were mainly about if you were a good fit for the organisation and if you came across as likeable. JSE interviews, though, are much more structured and competency focused and are assessed correctly and professionally. They're marked on a scale based on how many of the areas of the particular competency you demonstrate. They're not about coming across as likeable. One proviso to that is obviously what you have to show empathy in the competency about working and communicating with others. But whether or not the interviewers like you or you them doesn't really matter at all. I sit as an assessor for the police, and I've just actually today been assessing officers who want to go on and become chief constables. And working as an assessor really gives me an insight into how narrow the line is between pass and fail. It can be very, very close. And again, from doing that work, one common approach adopted in interviews is the scattergun approach, where candidates just try and get everything out, and I've been guilty of this, everything out in the time that they have, and inevitably, in the vast majority of cases, that leads to failure due to lack of detail. It's not unusual that I've seen for candidates who say twice as much to fail for lack of detail, and those who are more specific yet concise to actually pass. So it's not about how much you say, it's more about the detail of what you say. And it's better to focus in detail on one or two examples and give really specific details around that example that's directly applicable to the question asked in the competency. I'd recommend perhaps reading up a little about how competency interviews work and what interviewers are looking for, because if you have a little bit more understanding about that process, it'll help you if you're ever in that situation. And again, you can just use Google to search about competency-based interviews and see what it says. So when CILEX lawyers, as I mentioned, were first entitled to apply, I decided to as well. I filled in the application form. I took a qualifying test, which I got through, and I got to the final stage, which was a competency interview and a role play. And this was back in 2010. And I must admit, when I didn't get it, it really, really knocked my confidence. However, I continued to apply, again got through the last stage, and again, didn't do enough. At that time, there wasn't really any sort of training or coaching available. There was nothing offered by CILEX at that stage either. And I think the biggest mistake that I made was not keeping applying. As having failed twice, I thought, well, I'm probably not good enough. It's not for me. And I think now I wish I'd just kept on going and kept applying and taken the knockbacks as a bit of an opportunity to improve. But having a background in civil claims for the police, when I saw the chair of police misconduct roles advertised back in 2015, I knew that that was probably a good chance for me. So I went for it. It wasn't run by the JAC, but via local police and crime commissioners. However, the process was just as demanding. And obviously my appointment back in 2016 was a fantastic moment for me to get that. These misconduct roles are split regionally, and I initially applied to my own region, but also now cover Wales and the eastern region centred around Essex. The feedback you get from the JSC, it's definitely improved over the years. It was very basic in the early days. So if you do get to the final stage of the process, you will get this feedback, and it is very informative. And I advise anyone who gets to that stage and fails to ask for the feedback, because they don't automatically send it, and then work on that and get some training, get some coaching, and use that feedback really as an opportunity to develop. So the next part is really about the skills needed to do the job and the difference from practice. One of the questions often asked that I've had at these interviews is, how will you make the transition from practice to your new role? So you've got to really know your stuff and know why it's different to practice. So a lot of the skills that are needed will be very familiar to obviously those involved in contentious work, although their application and use is subtly different. One of the main skills required, obviously, is analysis and assessment of evidence. This starts when you get any written papers or bundles, and much as cases aren't prejudged, you will at this stage as a judge have an initial view subject to what happens in the live evidence. But quite often, as I've experienced, the live evidence can sometimes entirely change your view of the case. As a lawyer, I'd be mainly looking at evidence I needed to prove my case, what extra investigations were required to obtain the evidence. I'd nearly always obviously have a natural bias towards my client's version of events because I'd spoken to them and I didn't know how the other party would present themselves at court. But as a judge, you obviously begin with a completely neutral standpoint and you focus entirely on the quality and quantity of evidence. It doesn't matter when assessing evidence whether or not you like the parties, or if they're very forthright, or if they're very shy and very quiet. As a judge, really, you need to be looking closely at how the evidence supports the case or the defence, where there's any corroboration that supports one view or another, what weight you give to varying types of evidence, e.g. hearsay, written or oral evidence. Most importantly, once you've done this, you need to carefully consider the burden of proof and whether or not you have found proved on whether or not what you have found proved or not actually proves or disproves the case and meets the burden of proof. A key difference, and one that I struggled with at first, is not to think like a lawyer who's presenting the case in court. Because if you do this, you'll automatically be thinking about how you would have presented the case, what evidence you would have obtained and what questions you would have asked. And that's not your position. Because that's not the role of a judge. The judge is there to assess the evidence in front of them and not to think about what evidence is missing or how they would have dealt with the case in practice. You can, of course, ask relevant questions as a judge to get more detail, or you can ask legal representatives to ensure that they cover certain points in closing to help you in making decisions. But one note of caution on that point, when you do find yourself in that position, is when asking questions, don't step into the shoes of the legal representatives. There's been a recent High Court case which overturned a decision by the disciplinary panel of the General Optical Council, as the panel, in effect, stepped into the shoes of one of the legal reps and went too far in the questioning, and therefore they made the entirety of the decision unsafe, so it was overturned. So one key skill you will need to develop is the assessment of credibility of witness. Often you'll have a case where there's complete disagreement on every point, and you'll have to make a decision as to whose evidence you preferred and state why. I'd definitely recommend reading up on the latest court thinking on credibility to see how it's dealt with. As an example of a case that I dealt with, which was very difficult actually, credibility was crucial. It was a misconduct hearing for the police. And this particular case involved two police constables who actually lived together. The female PC made an allegation against the male PC that he had physically abused her for a number of years, and after one incident, she took the step of calling the police. The male PC alleged that she was the abuser, and for example, pushed him down the stairs on a number of occasions. So a key part of his evidence was that his partner was out to get him, and she was making everything up to ensure he lost his job and she didn't get found out. So myself and the panel, ultimately in this case, found for the female PC and dismissed the male PC from the job. And this decision was only possible due to a careful analysis of the evidence that helped when determining credibility. The burden of proof in misconduct proceedings, which is the same as civil, which is the balance of probabilities, was proved by the prosecution in our judgment due to very small and insignificant parts of the evidence that help with assessing the credibility. And this sort of, to me, just is an example of how thin that line is that I talked about earlier. So for example, the male PC's allegation that she was out to get him, we just didn't find that didn't stand up in court. And one of the things that really, really helped, there was a 999 call made following this, what was actually a slap to her face. And the operator, which is normal procedure, asked her if there'd been any previous incidents as well. She confirmed that he hit her before and he grabbed her around the neck when she was pregnant. So the operator took the details of the most recent incident and then came back to the previous incidents. And he actually said to the PC, so he tried to strangle you. And obviously this was the ideal opportunity for someone who was making it up and someone who was out to get someone else to just do that and say, yeah, absolutely, that's what happened. But instead, this female PC was very clear and actually clarified, no, he didn't try and strangle me. He just put his arm around my neck in a chokehold. And so by her playing down the significance of this incident, which she could have very easily made sound much worse than it was a very easy step to actually determine that she was the most credible witness. And it's those narrow lines and that attention to detail and analysis which you really need to be thinking about for doing this role. So again, it's never too early to develop the skills you need, and obviously that you need when you want to obtain a judicial position, because these will actually help you not only if you get that position, but actually help you get the role as well, and help you when you're making your application. Because basically, the more you think about being a judge and the competency questions from the perspective of a judge, the easier it will be to do the application, to do the interview, and ultimately do the job when you get there. I mean, I subscribe to a fantastic blog, which is online there, which is purely around civil litigation, but it's well worth looking at. It has some fantastic articles and case summaries about judicial thinking, particularly around credibility of witnesses, which is something I've used extensively to inform my sort of mind about how things work these days with the higher courts. So that's worth doing that. And subscribing to that, and you'll get a weekly email into your inbox. But I would search for the numerous sites and blogs that are out there as well on general regulatory case law, because there's a lot of case law out there, particularly around judicial reviews on the decisions of various tribunals, which unfortunately sometimes get it wrong. For example, obviously the general optical case that I mentioned above. And I find it's often easier to learn from the cases where things have gone wrong, because the court in those type of judicial review proceedings will actually explain in its judgment where the tribunal went wrong. And certainly for me as a judge, and if I'm applying for anything, I can take that and sort of see, oh yeah, so the right way to do it is this, and that's the wrong way. So it's a good way reading those particular cases, because it's very rare you get a court saying this court got it completely wrong and this is why. So it's well worth searching out regulatory cases for all of these various tribunals, for accountants, osteopaths, whoever they may be. The other thing to do is definitely the shadowing. I definitely highly recommend that, both the official and unofficial. If you appear quite often in front of a judge, I would say ask them if you can shadow them. Most of the judges are pretty open to that type of request, and I did the official, and then I did an extra week or two of unofficial over the years, which was really good. Again, I would say observe some cases, but not just say the obvious county court cases. I would look at tribunals like employment, like police hearings. Police hearings, for example, are 90% of the time in public. They're advertised in advance either on the local police force website or on the local police and crime commissioner website. They're conducted in the same way as a trial, but actually they're often more interesting than straightforward county court matters, and they often last a number of days. For example, the longest case I've been involved in was 15 days, I think, a 15-day hearing, which is quite unusual, but does happen. One thing, again, where you could perhaps get some experience and is a much easier route to actually be on a panel is and I do sit with a number of lawyers. The police misconduct panel is made up of a legally qualified chair, a senior police officer, and a lay member. But I sit with a couple of lay members who were actually lawyers who just didn't have the confidence to go for the chair role, so they actually applied as a lay member. Now this is a remnant of the old system, but lay members are actually administered by generally the local PCCs in your area. And obviously you don't have to stay within your own police area. You can go out to any of the local PCCs which are within easy reach of you and contact them to see if they've got any vacancies for lay members. And obviously if they have, or if there's some coming up, that's something you can apply for, and it's a much easier route. It's not as demanding as the JSC role, but you would then actually be part of a tribunal, you know, helping make decisions and actually getting paid for it as well, which is always good. So I would say maybe have a look on your local PCC website. If there's nothing on there, contact them by telephone and see when the likelihood of vacancies is going to come up, because that's a good route in. So yeah, thank you for doing this, and thank you, Lorna, for doing the slides.